Third tool is a will. When we're talking about the second part of estate planning and the distribution of your assets after you die, it's important that people have an understanding of what will happen to their assets if they did no estate planning. So the healthcare proxy and the power of attorney are two documents that are estate planning documents, but those are part of the living probate. And again, we're going to be able to avoid going to the probate court and getting appointed as a guardian or appointed as a conservator because we have these two documents. And that's going to work for quite a while if somebody's incapacitated. And if they're incapacitated temporarily, these are the perfect answer. Healthcare proxy, power of attorney. Okay. When we're talking about distributing assets after death, it's important that you understand what probate is when we talk about death probate. Okay, so probate is the distribution of your assets when there are no names on the assets except for the decedent. So I want you to picture all the assets that you have as single engine aircraft. So if you're a single person and you own all of your assets just in your name, those are all like single engine aircraft flying around in the sky. A lot of times we'll have couples that come in to see me and some of their assets are held jointly. So they might have their house, for example, that's a jointly held asset. So imagine we've got this weird looking house plane with two engines on it, and then maybe all the other assets are held in individual accounts. So husband and wife have maybe they have checking accounts just in their name, savings accounts just in their name. So we've got all these planes flying in the sky. When a person dies, all their assets that are just in their name, they're going to fall into the probate water. So imagine we've got this blue sky, bunch of planes, we got blue probate water, and now we've got this huge salvage operation of all the planes that fell that just had one name. They've landed in the water, and now we have to go through probate. What that is putting a new name on that asset and distributing it to the persons who are entitled to that asset. So if we have no estate planning documents that deal with probate after death, then we're going to have to follow state law. And the state law will require that people come forward and request that they're being made personal representative of the decedent. So that process is the probate process. And in order to file that probate, most people will hire an attorney. It will cost $3,000 to $5,000. If there's an emergency, it may cost more. If it's very complicated and contested, it may cost even more. The person will be made personal representative, and they will be required to post a bond unless everybody else who's involved in this estate assents to their appointment. That bond is like an insurance policy against the person in charge to make sure that they act appropriately with regard to the probate assets, so this salvage operation. They'll also be required to get certain licenses when it comes to big ticket items like real estate. The estate will be exposed to creditors, and the unfortunate thing about any probate is it will be public. So anything that happens, any contest in the estate, the distribution of the assets, the payment or non-payment of certain debts, those are all going to be made public for someone to look at if they went to the probate court and pulled up the file. So we can either get through this process with a will or without a will. So many people have heard of a will, and that is just a tool to get you through probate. A will all by itself does not allow you to avoid probate, it just lets you move through probate faster. So with a will, we will have people who have been nominated or appointed to be personal representative of the estate. The court has to approve this person because the person may no longer be appropriate or available to be personal representative. But that's the beginning process, and it's a way to avoid conflict between siblings, for example, is a person will be nominated by the decedent to be the personal representative of the estate. Secondly, most wills will let you waive the bond, so there's no insurance that has to be paid because we already know and like this person that's been chosen. And thirdly, we won't have to get any of these licenses either, because for the same reasons, the personal representative is somebody that the decedent knew and trusted to follow through with the appointment without much court supervision. So a will, although it allows you to move through probate faster, it still puts you in the probate process.